Good morning friends, Sat Sri Akal, Adab and Namaskar. This is my 216th video and this is in continuation to my consultation with my resident and bungalow owners who have already taken my services. I will rebrush that thought. Janam Patri is done. We are under an executive notice has been received, whether it is under the Cantonment Act or CLA rules or under the PP Act. This now is after the executive war, because if you do not take the executive war, you will jump to the judicial war. And my modus of operandi is that we will not move to the judicial war. We will move to the executive war. So now the executive has put his hands and finally he is issuing us a PP Act notice under any of these sections which I mentioned to you earlier. Let's say if it is a resumption notice, finally we will get a notice under section 4.1 and 5.1. And if it is for construction of the Cantonment Act 2006, we will get either the removal of that unauthorized construction under 5A1 and we can even get a notice under 5B1 of demolition of that same construction. Let's say we are doing some unauthorized construction and the department is not willing to issue us a notice, it can seal our bungalow also. Let's say if we continue with the commercial activity under 244, we do not go to the court and take a stay or whatever, the department can issue a notice under section 7 of damages. So these are some notices. Now let's presume resumption or damages under nowadays what lease notices are coming. These are the two major things which we are facing. So now we are in the step 3. This is, or step 4 I would call it. This is PP Act. We had filed the reply to the notice. Now we are sitting. Please understand friends, what is an estate court? An estate court is that the notice which was issued to us by the DO or the CO or the station commander moves to the estate court. Now that means that the defense estate officer or the cantonment executive officer has moved that application to the state officer that under section so and so this should be done. So we will get a notice on it by the state court. Fine. Once that notice comes under either of the section, make sure we under the limitation reply to that notice. These notice would be replied proviso in the limitation period of either 30 or 90 days as per the rules and laws. Now the limitation once is done, this is very important. Whatever we are going to file in the state court is finally going to become our pleadings, evidence for further on. So we are building our base. It's a very simple understanding. If your base is strong, if the building's foundation is strong, you will never lose. You know, people ask me, why do we lose in Supreme Court, High Court when we won in the lower court? Because these are two, lower court until session, you are mostly fighting your cases on evidence. So you are building your case. Minute you step into the constitutional courts, that is High Court and Supreme Court, you are only fighting on the laws of the canton, the area or the constitutional subsidiaries. So their evidence is not discussed, pleading is not discussed, it is only stated. But it has already been decided by making those issues. So issues become very important. Most of us, our advocates don't even go and get issues drafted. It's a normal procedure. The department will make 4-5 issues, the judicial system, and those issues are finally vetted. So no pleading, no issues. No issue, no relief. That's what my Guruji and my mentor taught me. So friends, this PP Act estate court is like lower court. So again, the notice made and the reply made would be by me, and it is going to run into 100 pages. entire evidence would repeat, maybe added to the notice, maybe those various RTIs. Now, the same process goes as per step 3. The client, before filing of this reply in the state court, will have a Zoom conference with me. Extended family will come up. The approvals would be taken. The special power of attorney continues, which is already tendered to me as a consultant of his. This now will carry evidence along with it. The first day of the state court, we will file our reply, and on the same date, if preference goes, we will file various applications in CPC, production of documents, everything what is necessary for us under order rule 12(8). So admissions of documents, non-production if they don't give us, then even we will ask for framing of issues minus the notice which stands on 5(1), inspection of records by the department, whether the notice is from DO and CO. We can inspect, it is written very clearly. We can ask for papers. I have people who have, and some of bungalow owners have done it. I myself in my PP Act had asked for my GLR, and I appreciate my DO at that time. He tendered me the full volume of GLR in the estate court. People say we don't get this GLR. Today you don't get it even after bribing anybody anything. So we will be filing these applications if permissible by the state court. We will make sure that to this reply which we've tendered, we have either a written reply by the now DO, not the state officer. That will be made sure. And a local advocate would be assisting me who will be attending these courts. Mostly the DOs and the COs courts are after lunch at 3 o'clock. The timing has been decided so that the advocates in the morning can be in their courts, and after lunch 3 or 4 they can be in the state court. So once again I request, please follow me on my websites and YouTube so that my client can be more educative. And I do presume by this notice and by these so many Zoom calls and talking, my client would be standing at a course where he knows what he is doing with me. So every time we do this, these applications, if not replied, we have the benefit of doubt. Tell me one thing, 100 judgments you come across in PP Act where the session courts have said and the Supreme Court, High Court has said that the DO or the officer by himself cannot be advocate, or can be the boss of his order. So the state office court cannot or will not ever pronounce an order against himself. But yes, he will have to do it if there is a lot of arguments in it. And even if he doesn't do it, the third step comes is that judicial now, because after this notice of PP Act, we again get 30 days. The third step comes that we will rush to the session court. That I'll talk in my next video. So these arguments will be done in the law court, in the state court. I will make written submissions for arguments in the court. If the replies on either sides are filed, we get some documents and we will file all this so that the state officer is supposed to listen to us before he pronounces an order against us. So friends, this is very important. So state court, don't take it lightly. Some people don't even attend the state courts and finally orders come and then they rush to the sessions court. Then they start talking of natural justice. We will not talk of natural justice. We will talk that we asked for all this and the adjudication was not done. The state court did not listen to this, did not tender documents. So this will be built up. So I hope you understand why this step is so important for when we are in the state court. Thank you.